On February 20th, Donald Trump lost a major legal battle. The Supreme Court struck down the sweeping tariffs he had imposed under emergency powers. Today, Washington is refunding billions of dollars that it has collected under those invalidated tariffs. But it is also charging US importers a new set of tariffs on goods entering the country. It means that despite the Supreme Court's ruling, US importers are still paying tariffs under other statutes. That could feed into higher prices for American consumers. It may even cost American workers their jobs. The ruling itself was decisive. By 6 votes to 3, the court found that the International Emergency Economic Powers Act, or IEEPA for short, gave the president no authority to impose tariffs. That left Washington with an enormous bill that it had to pay back to importers. It had already collected roughly $166 billion under those tariffs. By the end of July, Customs and Border Protection said it had certified around $100 billion in refunds. They were to be sent back to US importers that had already paid the IEEPA tariffs. But while the government was unwinding one tariff system, another one was already up and running at the border. In other words, although the Supreme Court closed the emergency law route for imposing the tariffs, Trump still had other tariff powers to wield. So, the administration could move quickly to preserve much of the tariff's economic burden on US importers. A coalition of 25 US states is currently challenging those replacement tariffs in court. Small businesses have also filed their own lawsuits. But as for now, the tariffs remain in force. So the big question is, how exactly are US importers still paying tariffs, even after the Supreme Court struck them down? The answer to that question begins with a 1-minute handover. At precisely midnight on February 24th, just 4 days after the Supreme Court's ruling, US Customs stopped collecting the tariffs imposed under IEEPA. Literally 1 minute later at 12:01, it implemented a separate 10% tariff surcharge, which applied to around 29% of annual import value. The administration invoked Section 122 of the Trade Act as the legal basis for this surcharge. It allows tariffs to be placed on imports within a temporary 150-day window under certain economic conditions. In May, the Court of International Trade ruled that the economic reasons cited by the Trump administration, including the US trade deficit, did not satisfy those conditions. But the ruling was stayed on appeal, which meant that Customs continued to collect the tariffs until they expired on July 24th. In other words, those replacement tariffs stayed in force for 150 days, from 12:01 on February 24th until 12:01 on July 24th. And yet, despite that July 24th expiry, tariffs are still in force today. How is that possible? The short answer is that the Trump administration had already invoked yet another new legal basis, Section 301 of the Trade Act, to maintain the tariffs after the July 24th expiry. The Section 122 tariffs were applied to an estimated 29% of annual US import value. The Section 301 replacement tariffs covered just 1 percentage point less, at 28%. That means Washington can not only continue its tariff regime under a new legal basis, it also managed to keep the share of imports exposed to those tariffs virtually unchanged. Yale University also estimates that after the July handover, the trade-weighted average tariff rate fell by just 0.3 percentage points to 11.1%. By August 11th, that estimate had edged slightly lower again to 11%. So, one replacement tariff system was able to almost seamlessly pass into another one with no interruption. How did the Trump administration manage to achieve that? What did Washington do during that 150-day window to make sure that tariffs broadly remained in place? The Section 122 surcharge meant US importers continued paying tariffs between February 24th and July 24th. The United States Trade Representative, or USTR, then used that 150-day period to build a case that would enable the continuation of the tariffs after that July 24th expiry, under Section 301. That case began on March 12th. USTR opened 60 separate investigations into the governments of the US's trading partners all around the world. It alleged that they were failing to block goods made with forced labor from entering their own markets. If this was true, it would allow artificially cheaper goods to circulate through those markets. That would leave US firms competing against lower-cost supply chains. To impose the new Section 301 tariff, this formal investigative process is mandatory. USTR had to ask the targeted governments for their response, receive evidence from businesses and other relevant groups, and hold a public hearing before reaching its conclusions. Those public hearings were held in late April. By June 2nd, USTR had concluded that 54 of the 60 economies had failed to impose and effectively enforce adequate blocks on imports made with forced labor. The other 6 economies had some prohibitions on their books, but they were still failing to enforce them effectively. After another round of public comments and hearings, the final tariffs were announced on July 23rd, just one day before the Section 122 tariffs expired. Section 301 represents a different legal basis from both 122 and IEEPA. For US importers, it made little difference. They still had to keep paying tariffs after the 150-day window expired. As for Washington, the findings of the investigations allowed it to continue applying tariffs. It could even apply them to products from the investigated economy which had no direct connection to the practice being investigated. That executive power is easy to overlook. By threatening to make access to US customers more expensive, Washington was able to exert leverage over its trading partners. And the specific case of Sri Lanka shows what that leverage could buy. The US is Sri Lanka's biggest overseas export market. Last year saw the US buy around $3.1 billion worth of goods from Sri Lanka. Much of that was in the form of apparel, which is an industry that employs around 300,000 people in the country. That's a big deal for a fairly small island nation. On June 2nd, USTR proposed charging American importers a new 12.5% tariff on most goods purchased from Sri Lanka. It was also considering a lower 10% tariff on goods imported from Bangladesh and Pakistan. Both countries are Sri Lanka's competitors for selling clothing to the US market. In other words, Sri Lankan factories faced the risk of US orders for its goods moving to those competitors because it faced an additional 2.5 percentage point tariff rate. In an effort to avoid that higher 12.5% tariff, the Sri Lankan government confirmed on June 18th that it would strengthen its customs screening to more effectively identify and block goods made using forced labor from entering the country. Then on July 10th, President Anura Kumara Dissanayake issued a regulation banning such goods from entering Sri Lanka. Less than 2 weeks later, USTR assigned Sri Lanka the lower 10% rate. Its official decision specifically cited President Disanayake's new ban as one of the reasons for assigning the lower rate. And so Washington had managed to secure a formal change in another country's trade rules even before the replacement tariffs had taken effect. It was able to turn Sri Lanka's much-needed market access to US customers into leverage through those tariffs. But whether Sri Lanka actually proceeds to enforce the forced labor ban remains unproven for now. There is still limited public evidence that the government in Colombo is tracing supply chains, or stopping suspect shipments, or penalizing Sri Lankan importers. And yet, American importers are still being charged an additional 10% on non-exempt Sri Lankan goods. That 10% cost can end up being pushed through American businesses, workers, and consumers. Let's use an example. Suppose a shipment of Sri Lankan clothing is valued at $100,000. Under the new Section 301 tariff of 10%, the US retailer importing that shipment owes US customs another $10,000 on top of any existing customs duties. The importing company is legally responsible for that payment, and it makes that payment at the border. The economic burden of that payment is decided by what happens next. The replacement tariffs began on July 24th, so there is not yet enough evidence to determine exactly where the economic burden will ultimately end up. But Trump's 2025 tariffs show how similar costs were transmitted. New York Federal Reserve researchers estimate that US importers bore 94% of the economic burden during the first 8 months of that year. By November, foreign exporters were cutting their prices slightly more, but 86% of the cost still reached US importers. But how did those companies then divide that cost between profits and customer prices? A regional survey in May 2025 observed that about 3/4 of affected businesses had raised their prices by at least part of the tariff-related cost. The other 1/4 or so had absorbed the entire increase themselves. Then there are American workers, who could also end up bearing part of that burden. If tariffs raise a company's production costs or reduce its sales, it may hire fewer people, or limit wage increases, or reduce working hours, or even cut jobs. The Federal Reserve also did some research into the tariffs implemented in 2018 and 2019 during Trump's first term. It found that those tariffs benefited some US manufacturers because products from foreign competitors became more expensive in the US market. But the tariffs hurt other US manufacturers that had to pay more for imported raw materials and components. And then, when retaliatory tariffs were adopted by other countries, US exports became more expensive in overseas markets. As a consequence, the Fed found that domestic industries that were more exposed to those tariff-related costs performed worse on employment than the less exposed industries. And so American workers in those exposed industries face part of the economic cost through weaker employment prospects. As for the Section 301 tariffs, Washington has used access to US customers to secure changes in trade rules in countries such as Sri Lanka. The immediate domestic cost of that policy is clear. American importers now pay the new tariff, but as for now, it remains uncertain where that cost will end up. Importers may absorb it through lower profits. They could also negotiate lower prices from Sri Lankan suppliers, or raise prices for American customers, or perhaps reduce other business spending. Evidence from earlier tariffs show that all these responses can occur. And that takes us back to the refunds. The Treasury has started refunding the payments collected under the IEEPA tariffs that were struck down by the Supreme Court in February. The refunds do not cover the new Section 301 tariffs that replaced them. So we now have a situation where an importer might well have recently received a refund for an IEEPA tariff on an earlier shipment, but that importer might still be paying the new 301 tariff on a shipment arriving today. What's more, the importer might have already transmitted part of the cost of that IEEPA tariff through the US economy. So we must ask, can those refunds reverse all of the cost movements since the tariff was initially paid? Not quite. Let's assume an American importer paid $10,000 under the invalid IEEPA tariff on an earlier shipment. The importer, or its customs broker, submitted the eligible shipment records through CAPE, which is the electronic system that Customs introduced to consolidate and process IEEPA refund requests. Customs then removed the invalid tariff from each accepted record and recalculated the amount that should have been paid. It then certified a refund of the tariff, together with interest. And finally, Treasury dispersed that money to the importer of record. By July 31st, approximately $100 billion in tariffs and interest had reached that stage, completed and certified by Customs, and sent to Treasury for disbursement. By August 13th, over 40 S&P 500 companies had reported approximately $9.6 billion in refunds or expected recoveries, including at least $2.1 billion in cash already received. That's more than a symbolic victory for importers who paid the IEEPA tariffs. They were due a large amount of money. But Customs can only correct what happened at the border. It does not know whether the retailer later raised its prices, or whether a foreign supplier lowered its own prices and accepted less money to remain competitive, or whether workers lost hours, incomes, or even their jobs, or whether an order was cancelled altogether. If the importer absorbed the tariff through lower profits, the refund repairs that loss fairly directly. But if the costs move deeper into the market, the refund does not automatically follow that journey. That makes traceability to the customer a hugely important part of the refund process. Most tariffs do not reach customers as a separate, traceable charge. Once the cost has been blended into product prices, supplier terms, and profit margins, identifying who carried each dollar becomes nearly impossible. And so the outcome of each refund depends on whether or not the original tariff payment can be directly traced back to a particular customer. For instance, FedEx was able to collect tariff payments from individual customers and then pay that money to Customs on their behalf. So when FedEx received around $800 million in refunds, it could return that money to those customers. That is a relatively straightforward case. The customer paid a visible tariff charge, FedEx had a record of that payment, and the refund could easily follow the same path backwards. But most tariffs do not reach customers so easily. In many cases, they represent just one cost among several within a company's pricing decisions. A retailer may raise the price of one product, or absorb part of the cost on another product, or it may demand a discount from a supplier, or even spread the extra costs across thousands of different items. Once that happens, identifying exactly which customer carried which part of the tariff could be virtually impossible. Amazon, for example, has said it will issue refunds in the limited cases where it can trace the tariff directly back to particular customers. Elsewhere, it says the recovered money will help support lower prices more generally. Other companies have recorded large recoveries through their earnings. Nike recognized an expected tariff recovery of $986 million. This has added 52 cents to its quarterly earnings per share. But that does not necessarily mean that Nike received a $986 million windfall. Earlier in the financial year, the company had recorded the tariffs as a cost, which reduced its profits. The tariff refund then later reversed most of that recorded cost. That refund made Nike's quarterly earnings jump. But across the year, Nike said that the refund mainly restored profit that the tariff had previously taken away. Even so, the account still cannot tell us whether every customer, supplier, or worker who carried part of the earlier tariff cost eventually got their money back. So where does this leave Trump's tariff system? The new tariffs are operating, but as for now, their future remains uncertain. 3 indicators will tell us whether Washington has genuinely preserved its tariff power for the long term or merely bought more time. The first indicator to watch is the court ruling on the new Section 301 tariffs. Businesses have filed 2 separate legal challenges against those tariffs, and a 25-state coalition has filed a 3rd one. The central issue is whether Section 301 can support tariff actions this broad. The law allows USTR to respond to particular foreign practices that burden American commerce. But the challengers are arguing that Washington decided to first maintain the tariff and then use the investigations to legally justify its predetermined tariff policy. If the courts broadly uphold the new duties, the administration will have secured a more durable replacement for the IEEPA tariffs. An adverse ruling would not necessarily eliminate the entire replacement system. USTR structured the program as 60 separate tariff actions, so a court could invalidate one economy's tariff or part of an action without automatically eliminating the rest. But a ruling against a legal flaw shared across the entire program could have much broader consequences, including new claims for repayment of the affected duties. And unless a court suspends collection, American importers must continue to pay the tariffs in the meantime. The second indicator is the realized average tariff rate. That is the amount of tariff revenue actually collected relative to the value of goods entering the United States. The headline rates of 10% or 12.5% are only the starting point. We also have to take into account product exemptions, which reduce the reach of the tariffs, trade agreements, which protect some shipments, other product-specific duties, which can increase the total charge, and businesses that move their sourcing into countries or products facing lower rates. So, the realized average tariff rate captures the combined result of all those decisions. If it remains elevated, it would show that US importers are still facing a substantial overall tariff burden at the border. But because that figure also includes other US tariffs, it cannot tell us how much of that burden comes from the new replacement system. And the third indicator is where the new tariff obligations and the old tariff refunds eventually settle. FedEx and Nike have already shown us two starkly different possibilities. If the original payment can be cleanly traced back to a specific customer, the refund can follow the same path backwards. But if the tariff has been blended into product prices and company accounts, the refund may instead appear as an earnings recovery. For investors, that means separating one-off tariff refunds from the underlying performance of the business. A company can report stronger quarterly earnings because an earlier tariff cost has been reversed, even while sales, orders, or operating margins remain weak. For customers and workers, the important signals to observe will be changes in retail prices, supplier contracts, orders, investment, and hiring. Those decisions will help show where the tariff cost ended up and which businesses were able to pass it on to their suppliers, customers, and workers. Together, these three indicators answer three different questions. 1. Are the replacement tariffs legally durable? 2. How much of the overall tariff burden is collected at the border? And 3. Who ultimately carries the cost? So we can now answer the question at the very heart of this story. How exactly are US importers still paying tariffs, even after the Supreme Court struck them down? Simply put, because the court only struck down the tariffs imposed under one legal authority, it did not prohibit the wider policy of using them. The court decided that IEEPA did not give the president the power to implement them. But Congress had already granted the executive branch other, more specific tariff powers. The administration used Section 122 as a temporary tariff bridge to buy some time. It then used Section 301 to construct a replacement tariff regime. That ability to change the legal route for justifying the continued use of tariffs is itself a form of institutional power. It allowed Washington to preserve much of the pressure while businesses, trading partners, and the courts tried to catch up. Countries such as Sri Lanka changed their import rule so as to preserve their access to US customers. American importers still had to pay customs because new tariffs were already in operation. And those importers could still move part of the cost of the tariffs into supplier prices, customer prices, profits, orders, and employment. None of this makes the Supreme Court's ruling irrelevant. The judgment imposed a genuine and meaningful constraint on presidential power. It created an enormous refund liability, and it forced the administration to justify its tariffs through laws containing more specific procedures and limits. The replacement tariffs may still be narrowed or invalidated through those legal challenges, but the ruling did not remove tariffs from Washington's economic toolkit. And so if alternative routes remain available, the policy and much of its economic burden can survive. For now, Washington preserves much of its leverage, and US importers continue to receive the bill. If you found this analysis useful, consider hitting the like button and subscribing to the channel. Here at Markets in Power, we examine how states, institutions, and corporations exercise power, and how markets, capital flows, and economic outcomes reveal the consequences of those choices. Thanks for watching, and I'll see you in the next video.